SJC-13231, Commonwealth versus Brittany Smith.
Okay, Attorney Shea.
Good morning, Your Honors. Richard Shea for Brittany Smith. The issue I'd like to address this morning is the denial of the motion for change of venue. It's clear from the case law that the denial is, the issue of change of venue is to be reviewed for the totality of the circumstances.
And when we review it on appeal, what standard do we use? Do we use a de novo standard, or do we review this for abuse of discretion?
The case law in the Commonwealth says abuse of discretion. I submitted a 16L letter a week or two ago, which quoted the Shepard versus Maxwell case from the U.S. Supreme Court, which states that an appellate court should give an independent evaluation of the circumstances. So there is a somewhat heightened review of appellate.
So the Maxwell versus Shepard, you're saying, says there should be a heightened review or a de novo review?
It says an independent evaluation of the circumstances. Okay. Yes. And I think that that is reflected in this court's cases implicitly, because the cases have gone into a lot of detail in analyzing the statistics and the circumstances and the voir dire and so forth, beyond just an ordinary review saying, well, the voir dire of the potential jurors was adequate. In this case, there are a number of factors that have been identified in the case law which are to be looked at. The cases say that the adequacy of the voir dire is the most important factor, but it's not the only factor. And I'm not challenging the judge's preparation for the voir dire, the questionnaire, the questions, the opportunity of the attorneys to ask questions. The individual answers as accepted by the judge for the seated jurors, I wouldn't challenge them individually. However,
that's pretty difficult then. If you're not going to challenge individually, don't you concede the first step of the analysis? I don't quite follow where you're going with that.
The adequacy of the voir dire is only one factor. An important factor also identified in the cases, I think Skilling versus United States sets them out, and other cases have repeated them. The extent of pretrial publicity as shown in the record, and here we have the trial attorney submitted 2 affidavits, one just before the Hart trial and one just before the Smith trial, with many, many copies of pretrial publicity. The somewhat sensational.
Well, you don't argue presumptive prejudice, Mr. Shea, correct?
I'm sorry?
You do not argue presumptive prejudice.
I'm not arguing presumptive
Because
prejudice.
of the
I'm not saying that I shouldn't say sensational. I would say very emotionally charged.
Sure, given the nature of the crime.
Yes, and the emotionally charged nature of the crime is reflected throughout the voir dire. The judge admitted, I mean, the jurors kept bringing it up. And the judge would repeatedly say, yeah, we recognize this is horrific, but we want to inquire to see if you can put aside your emotions and decide the case impartially on the
And you think
facts.
that went all right? You're not challenging those individual responses?
The problem with that is the cases also say that where there is a high percentage of jurors who have prior knowledge and of jurors who are excused for bias based on prior knowledge, there is a danger that even though jurors express lack of bias, and so found by the judge, that I think the Hoos case says there remains a shadow of a doubt about the impartiality of the jurors who were seated. In the Morales case,
But I'm confused. If you're not making the presumptive prejudice argument, and you're not challenging the individual jurors, is there any case like this where that fits in between one of those two categories? If, again, you're not challenging presumptive prejudice and you're saying that the individual jurors are properly seated, and we should nonetheless still have had a change in venue?
I'm not saying that they were properly seated. I'm saying that the judge did not, in the individual voir dires, I would not challenge on appeal an abuse of discretion in finding that juror based upon the answers.
Well, I thought we were
But-
going to do this on our own, like evaluate everything independently,
Well, yes,
but
I'm not arguing the individual
right.
jurors and the judge's findings that they could be seated. I'm arguing that in this case, there are 134 jurors called. The 30 of them were excused without any inquiry into whether or not that they knew anything about the case, which leaves 104, and of those, there was 92 had prior knowledge of the case, which is 90% of the veneer, which is an extremely high number.
Mr. Sheikh, I understand you're asking us to take a holistic view of this and not.
Yes.
And then you focus on the 90%, 10%, and then as it breaks down, 11 seated that knew something about the case, 3 that didn't. In your guidance, can you tell us cases that use this granular view of these numbers, where that say go, no go, based upon change of venue, where the judge should have just said, all right, I've seen enough, I can't get a fair jury? What's the closest case? How can you help us in that?
I don't have a case in this court where there's been a reversal on that basis. The only reversal in recent history that I know of is in the Tulin case, which was unique in that the judge did not individually question 4 of the seated jurors. But I also note that only 45% of the jurors in the Tulin case of those questioned had read of the
So that the
case,
percentages-
which is rather a significant contrast to the 90% in this case, which, again, it was an extremely well-publicized and emotionally charged case when it was reported. When it came time for the trial, there was a resurgence of publicity, which is an important factor.
So do you think those numbers in and of themselves, Mr. Shea, would lead you to the conclusion, or should have led the judge to the conclusion that he could not pick a jury, a fair jury, even doing the best that he could with a questionnaire and appropriate questions?
That's one of the factors. Another important factor, which I do emphasize, is the fact that Hart went on trial just before Brittany Smith, and he was convicted, and it was well publicized that he was convicted on April 13th. Her impanelment began on the 24th. We had 3 jurors who were seated who knew of the Hart trial. One of them had acknowledged that he knew the verdict. The other said they didn't know. But as one of the jurors questioned, one of the others not seated who was questioned said, I can figure it. I knew of the trial. I didn't know the outcome, but I can figure it out. I would have heard about it if he had been acquitted. So it had a danger of the knowledge of the Hart trial seeping into the jury deliberations in this case.
When juror number four is one of the jurors who's heard about the case, were there peremptories left when juror number 4 is picked?
No.
So they're out of peremptories at that point?
She ran out of peremptories, and she requested more, and the judge denied it.
Okay, so again, when the juror 4 was, you're sure on juror 4, she had no peremptories at that point?
Juror 4 is the very last one seated. She had no peremptories left at that point. Yeah, it stated, the clerk states that on the record.
But you're not arguing that there's a problem with the seating of juror 4?
No.
Why not?
As part of the overall, I'm not arguing the original.
Well, it's just, change of venue is designed to prevent, right, the seating of jurors who are problematic. In a case in which you're not challenging any of the seatings, including of juror 4 who actually had heard the verdict, it's just hard to sort of understand all the logic of that.
I did not know that juror 4 had known of the verdict. Maybe that must be my error.
He had heard, I'm just reading from the Commonwealth's footnote, he had heard that there had been a conviction in a prior case, but did not follow it closely and would judge this case separately. Transcript 2.
Transcript 2?
Transcript volume 2.
It was transcript volume 4, which the last juror was seated.
I'm not sure you're talking about the same juror then, because juror 4 is in.
You may be talking about seat 4 versus juror number 4. That might be the discrepancy.
Yeah.
I think that might be what we're talking about, 2 different things.
Okay. I'm not talking. I'll stand by what the transcript says in volume 4 about the last juror seated after she had.
I think I have a general sense, and I think we all do, if I don't want to speak for anybody, but of your argument, which is that you're taking, as Justice Gaziano said, a holistic approach to
Yes.
this, and that you are asking us to look at it that way. I'm wondering, in light of the amount of time, if you could address your next 2 issues regarding sufficiency of the evidence.
Well, the sufficiency of the evidence with respect to Mr. Hardy was that they were planning to steal a car, and they planned a home invasion, and they were going to either scare or hurt the inhabitants so that they could steal money and credit cards. I think the evidence is clear that when they entered the house, she did not, neither Hart nor she said that they had an intention to kill Mr. Hardy. She did not, Hart, according to the statements, Hart went immediately to Mr. Hardy and began stabbing. And Miss Smith had followed him into the house, and then he gave directions for her to attack the woman in the wheelchair.
And did she follow that?
So she did not. So there's no evidence that she had premeditation to kill Mr. Hardy, at least that she lacked the malice for the other two.
I think the Commonwealth may have tried this one on a joint venture theory.
Yes.
So did she know about Hart's possession of the knife?
Yes, she did.
Okay.
With respect to the premeditated murder of Miss Fisher, she testified that she did not intend to kill her, that she followed his directions, and the worst thing she did was stab at the side but didn't penetrate the clothing.
Although didn't the medical examiner say that she died, that there was a stab wound to her lung? I thought, or am I mixing that up with the first person?
There is, yes.
Oh, there was, okay.
Yeah. That could have been inflicted by him because he began stabbing her after my client said she couldn't do it and threw the knife on the couch. And then he picked it up and continued and sent her off to steal things from other parts of the house.
Can I ask you one last, just Cypher, you done on that?
Yes, thanks.
Okay. I don't understand why this isn't an abuse of discretion. Have you read the Tsarnaev opinion to the U.S. Supreme Court's decision, Tsarnaev? Because they're emphasizing that this is a discretionary choice throughout the opinion. And Shepard, if I remember correctly, that's Dr. Shepard. That's like
Yes,
a 40 or
it is.
50-year-old case, right?
Yes, I have not read the scenario.
Okay.
I think the last point I'd like to make is that 64% of those who had prior knowledge coming into the courthouse were excused for bias, which is another high number to be contrasted with what I quoted in the Angiulo opinion, where it was 47% of the Veneri were claimed to have knowledge of the defendant. I think I'm incorrect relying on not the percentage of the Veneri. It would be the percentage of those excused for bias. And I believe that's the only additional point I wanted to make. Thank you.
Thank you. Okay, Attorney Von Flattern.
Good morning, Madam Chief Justice, members of the court. Cynthia Von Flattern, Assistant District Attorney, Northwestern District for the Commonwealth. Starting with issue number 1, the Commonwealth would submit that there was neither prejudicial or presumptive prejudice in this case or actual prejudice in finding a impartial jury. The standard of review is abuse of discretion, and in this case, the judge had wide discretion and used it carefully to find an unbiased and fair, impartial jury. I think if you will look at the numbers, in this case, the jurors, there were 134 jurors. Those that were excused because they had a medical appointment or medical issue or something like that, we can't infer that they were biased or knew something about the case due to prejudicial publicity. The judge conducted a voir dire of all of those individuals. And in fact, I think in reviewing this case, I think there were only about 25 jurors that said that they did know about the case and felt that they could not be impartial. Specifically, if they had heard about the trial for the co-defendant, Mr. Hart, and some of those said that they knew that and they reluctantly felt that she was probably guilty too, or they may have said that, well, they've made a determination she is guilty. Some of the jurors...
That was 25 of what's the denominator?
That would be 25 would be the numerator and 134 would be the denominator. So that would be, I believe, Your Honor, under 20%. As the court is aware...
So 1 and 5 were bias.
Yes.
Okay.
And many of the... So some of the people were biased due to prejudicial publicity, not prejudicial publicity, but some publicity. Others in this case were excused because they were from Orange, perhaps, and they knew the victim's family, or some of them knew the defendant's family members. Some of them may have worked with the EMTs or one person knew something about the defendant's children in this case. So there were those issues, but it had nothing to do with publicity in the case. Those are just normal things that the judge found. There was a 10-page questionnaire that was developed by the parties and the judge, and the parties and the judge went through this.
Of the 109 that were left, what percentage had heard about the case?
That had heard about the case, well, many had heard about the case.
So what percentage was that?
It could have been 80%. But I don't think that that's the issue, and I think that the case law is clear that's not the issue. Commonwealth versus Hoos would say you look at what percentage were excused due to a challenge for bias or because of knowledge of the case. Some of the people, most of the people knew about the case, had heard some minimal information about the case, but that did not cause them to be biased. And it was very clear in this case, there was a summary that was presented to all of the potential jurors, and most of the jurors knew far less than what the summary had said. An exception would be that certainly the summary is not going to say that the co-defendant was found guilty. So that would be a different scenario if they had heard about the previous trial. And I would submit that there was one juror, number 4, that did tell the judge that he had heard about the prior trial, but he was very clear that he felt that was a separate issue, that was a different case. And he was juror number 4. There were many...
were there peremptories left when juror number 4 was picked?
Yes, there were many peremptories left at that point. With respect to peremptories, there was basically three mornings of jury selection. It went into the 4th day, and on that day, the defendant used her last peremptory. Every juror after that, there was no issue about publicity in that case, and finally, the last juror that was chosen had no information about the case, and that was very clear. So I think in this case, Commonwealth versus Hoos, I think, is most instructive. That was also a Franklin County case. And the judge in our case took great pains to conduct that individual voir dire and assure, for whatever reason, that a juror could be unbiased. It many times wasn't because of publicity that there might be an issue. It was because they had sympathy from the victim after reading the questionnaire, or they were not going to like the photographs in the case, or something like that. But the judge considered all of those issues as well to come up with a impartial and unbiased jury in this case. If there are no other questions, I would just go to the second issue with respect to whether the Commonwealth proved this case beyond a reasonable doubt for each theory with respect to each of the victims. My brother argues that the Commonwealth failed to show premeditation in the killing of Mr. Hardy. This was always, with respect to Mr. Hardy, the male victim, this was always a case of joint venture, and there were many factors to show that the defendant participated meaningfully with Mr. Hart in this killing, and that she shared his intent. Starting with, much of this comes from the statements of the defendants, but also from the physical evidence, and also from the one excited utterance of Mrs. Fisher. So it was.
And just to, since since this defendant is riding on the other defendant's intent,
Yes.
what was the evidence of of her companion's intent?
Ms. Smith, the defendant, testified that he armed himself with a knife at his grandmother's house. Then the two of them walked 2 miles to the victim's house. When they stopped at her grandmother's house, where she changed her clothes and actually had an extra set of clothes, and then they went and cased the area looking for a house to break into. They went to a few houses and found that they couldn't get in. They went to this house where they saw Mr. Hardy, age 95. They didn't know exactly how old he was, but they knew that he was older. They saw that the house was open, that they could get in, because they looked in, they saw in the garage a car. They saw that it was an older car, and they felt that it would not have a tracking device, so they wanted to take that car. They went and tried to break into the house. Mr. Hart testified that he tried to take like a screen off of the crawl space. He thought he could get in that way, but the crawl space did not go anywhere. Ms. Smith was right there. Her fingerprints were found on a window of the house, and the testimony was that window, or windows that they had looked into, showed you could see Mr. Hart from those windows. The defendant's palm prints are also on the windows of the garage. The two people go into the garage and arm themselves with socket wrenches from the garage. Before they even get into the house, after the door is open from the garage into the kitchen, they see Ms. Fisher, and then they enter with Mr. Hart. At that point had a knife, and there is testimony, or there is in his statement, he states that she probably took a knife as well. There was at least one knife, and there may have been 2 knives as well as the socket wrenches. So and also just with respect to what their intent was, they both admitted that they intended to steal a car and escape so that she would not have to deal with her having to go to be committed for drugs, and he would not have to deal with his criminal case. And she also had a criminal case that they would have to not deal with this. But as much as in their statements they would try to minimize and perhaps say we just wanted to steal the car, in fact, Ms. Smith admitted that the keys were in the car, that they knew the keys were in the car, yet they entered the home with weapons and immediately set upon Mr. Hart and Ms. Fisher. And that resulted in Mr. Hart's death by stabbing. There were 3 wounds to his heart. He basically bled to death. Also, the wound was to his lung as well. And Ms. Fisher, as the court knows, was injured. There was one stab wound to her left side, and the cause of death was Ms. Fisher suffered on the floor for 12 hours and died 5 weeks later, and the cause of death was exacerbation of her chronic obstructive pulmonary disease by these additional injuries, particularly the stab wound. But there were also cracked ribs and wounds to the neck, a bad bump on the head, and those kinds of things as well. So there was shared intent and meaningful participation in Mr. Hardy's death. And there was also Ms. Smith, the defendant, acting more individually with respect to Ms. Fisher, but even that was also a joint venture because Mr. Hart also participated in the attack on Ms. Fisher. So I would submit that the evidence was overwhelming with respect to malice for Ms. Fisher, as well as specifically premeditation, extreme atrocity and cruelty, and felony murder. And the felonies, the predicate felonies, were the burglary while armed and armed robbery. And the defendants were convicted of the armed robbery on both individuals as well. If there are no further questions, the Commonwealth would rest. Thank you.